To now have Professor Michelle Mello, as I talked about before. The students actually said this is who they want to hear from. The kids are going to figure out the computers on their own. What they want to know, what's the legal, what's the ethical guidelines, just what are the boundaries, and they're just going to go wild within that space. And it's a very rare occasion we have access to an actual legal expert who's focused in this area. Please, Professor Mello, take it away.
Thank you.
And how about a giant hand for Dr. Mello?
Thanks very much. Pleasure to be here. Physicians have a lot of questions about their malpractice risk in general, and even more about their malpractice risk when it comes to AI. And so what I was asked to talk about today is what do trainees and young physicians need to know about this area? And my message for you today is I think it's reasonable for people to have concerns about this area, but it would be a big mistake not to move forward with adoption and use of useful AI tools just because of fear of liability. Now, before I get into explaining why I think that's the case, let me just offer a couple of disclosures. I do have some relationships with companies that produce AI. I also run a lab here at Stanford that's focused on ethical evaluation of AI tools for the hospitals. And part of the reason that experience is relevant is that what I take away is that the same conclusions that we reach in terms of what responsible use of AI tools looks like from an ethical perspective are the things that will help manage legal risk as well. The law of medical negligence is all about what the reasonable person would do. And so by adopting basic tenets of responsible use of AI, I think it's fair to say we can protect physicians fairly well from liability. Now, if you go to a continuing legal education program today and you go to a session about AI liability, you will get a very different message from lawyers who make their living advising clients about protecting themselves from liability. So these are some little snippets from CLE programs that I came across recently. I'm talking about the potential legal ramifications of experimenting with healthcare AI. And you can see this one graphic, they've got a sort of like uranium core of AI innovation surrounded by a mushroom cloud of devastating legal consequences ranging from malpractice liability to fraud and abuse to debarment from federal programs. So again, there's a lot of rhetoric about the potential liability, and it is true that there is uncertainty out there. There's uncertainty out there because it is new, not because there are things about this that create potentially explosive consequences for providers. Now, I did say I think it's reasonable to be concerned. Well, why do I think it's reasonable? I think there are some things that are distinctive about this technology that create interesting problems for legal scholars. One is that it comes to patient care with much less testing and vetting than drugs or medical devices in general, and therefore there's just greater unknowns and potential for patient injury. Another is that we're talking about problems that can occur at scale. When we're using these tools at scale, injuries can replicate over many, many patients, and from a lawyer's perspective, that means big damages. Another issue has to do with the humans that are using the tools, particularly for generative AI, because they work so well so much of the time, it's very easy to become complacent as users, to over-rely on them. And this techno-optimism can lead people to not be great governors in their personal use of the tool. Another issue is at the institutional level. Although superstar institutions like Stanford do a great job of vetting tools before they're implemented and a good job of monitoring once they're implemented, that's not true of most organizations. Most organizations don't have robust vetting and governance schemes. And so at the level of choosing the best tools or tools that fit the problem well, there may be some gaps. Then you've got just the sexiness of AI-related injuries. They're much more of interest to reporters than the garden variety injuries that happen to patients every day, misdiagnoses and medication errors. These things land in the paper, and that freaks lawyers out. And then when we think about the pool of potential jurors who would be seated in a courtroom to adjudicate these claims, they are, on average, people who are coming in with a high baseline distrust, not just of AI tools themselves, but of you all and of the hospitals that you work for. Majorities of Americans repeatedly in polling say, I don't trust healthcare AI, I don't feel comfortable with it being used in my care, and I don't trust hospitals to be doing a good job of overseeing it. And so they're coming in maybe with some priors that are not particularly defendant-friendly. You might add to that the fact that we don't have much formal regulation of AI tools. As a legal scholar, I understand that historically, when that is the case, the courts step in to fill that gap. That's a gap that's not going to be closed anytime soon. There's not a lot of robust activity going on in Washington right now to regulate AI safety. And so when courts start to see consumers hurt repeatedly by a new product, a new technology, and there's not an agency that is going to step in and deal with that problem, they will create pathways for people to get recovery for that injury. Another observation as a lawyer is that the companies that are producing AI are very, very good at making sure that to the extent that there is liability, it's not going to fall on them. And they do that through private contracting. Many of the terms of service that they sign with institutions will disclaim liability for personal injury, shunting that onto the hospital or onto individual clinicians. And they even disclaim ordinary consumer warranties, representations that when you make a product, it's fit for its intended purpose. Other product makers are not permitted to do this. There's a federal law that says they can't do it. It doesn't apply to software, and lawyers have figured this out. So what does that mean? It means liability will be flowing to users. And here's an example, one of many you can readily find online. This is from OpenAI's Terms of Service for ChatGPT. And take a look at the language here. You must not over-rely on this tool in making medical decisions, but you must not use it to make any important decision, including medical decisions. Do they know that people do? Of course they do. Nevertheless, will this hold up? Yes, it will. Finally, there's the question of informed consent. Patients can bring a regular medical malpractice claim when they get injured, saying your negligence hurt me. And then another thing they can do is layer on an additional claim for damages for breach of informed consent. And they can do that when you fail to disclose information that a reasonable patient here in California, or in some states, a reasonable physician would consider to be material to their decision to accept a treatment or to recommend a treatment. Now, if 60% of Americans say, I'm uncomfortable with AI being used in my care, there's an argument that's material information. And so when that use of AI is not disclosed, it creates the possibility of additional claims for breach of informed consent. Again, if they could credibly argue, look, I wouldn't have accepted this mammogram or this particular surgical modality had I known AI was involved. So there's lots here on the ledger to be concerned about. Unfortunately, there's very little coming out of the court system right now to tell us how courts are processing all of this uncertainty. Very little signal. And that's, again, just because it's so new and the legal system is very slow. And most claims for medical malpractice don't get resolved in courts. They get resolved in insurance companies quietly through settlements or dismissals. So it's very, very hard to understand how judges will be thinking through these problems. And to be honest, having given continuing judicial education to some, they don't know either, because most of them have never had a case like this yet. What we can say is historically, again, when something new happens and it is up to the courts to kind of stretch legal doctrine to fit a new situation, they'll get there. But in the interim, particularly in the healthcare space, it's often individual healthcare practitioners who get stuck with liability. They're kind of the liability sponge while all this stuff gets worked out. And so again, my conclusion is very reasonable to be worried about this stuff. Now, I've got a lot of points on these slides about why you should be upset. I've only got 3 points about why I don't think it's a catastrophe, but those 3 points are really, really powerful. So let me give the counter argument here. This is based on maybe 25 years of research about the epidemiology of medical injury and malpractice claims. And what I can tell you with a lot of evidence behind these statements is vanishingly few instances of doctors hurting patients through negligence become claims. If you ask physicians what the percentage is, they'll give you a number around 60%. I hurt a patient by negligence, 60% chance they're going to sue me. Actual number, 2 to 5%, depending on the severity of injury. And of those, about half will take any money at all out of the system. Fact number 2 is there just is not much evidence that anybody is suing over AI right now. When I've looked through cases systematically, as well as newspaper reports, jury verdict reports, industry newsletters, very, very hard to find any evidence at all To the extent that we have AI-related lawsuits, it's mostly about cars. And again, when you speak to judges or when I speak to insurance companies, they've yet to give me a fact pattern that has come across their desk, not one. So it just doesn't seem to be happening yet. And then finally, although I understand that for physicians, it's the getting sued part that's really painful, not what ultimately happens 2.5 years down the road. What ultimately happens 2.5 years down the road, I think, is very unlikely that patients are going to prevail on a lot of these claims, at least right now. So let me spend a few minutes talking about why that is, why it is so hard for plaintiffs to win these kinds of claims, at least when you sort of look theoretically at the doctrine. So when we looked through the literature, we found about 800 cases where software produced a physical injury in a person. Again, most were outside of healthcare. When we sort of honed in on the healthcare cases, there were just about 50 of them. Most of them don't relate to AI. But here are the kinds of fact patterns that come up, just as a way of establishing what plaintiffs are trying to accomplish in these cases. So one cluster of fact patterns is that there's some software that is used to manage hospital care and something goes wrong with that hospital or that software. The plaintiff will sue the hospital and they'll sue the developer. And here are a couple of examples here in the top row. A second group of cases, and maybe more of concern to individual physicians, are these ones in the middle where the physician is using some kind of software to generate a clinical decision of some kind. And it seems that the decision was wrong for a particular patient. The patient, who's then injured, sues the physician for relying on that software, and he'll also try to bring in the software developer. And here's a case called Samson in the middle here, involving a cardiac screening algorithm that, for reasons that even I as a layperson don't understand why, would not include family history, didn't include family history, and a young man dies of a sudden cardiac death. And then in the third category here at the bottom are cases where there was like a physical device that was driven by an algorithm, driven by software, and that software malfunctioned, and the device itself hurt the patient. For example, some kind of morphine infusion. So these are like the types of fact patterns. In all of these cases, the plaintiff has the burden of proving their claim. They have to prove it by a preponderance of evidence, 51% probability. And what exactly do they have to prove? If you come to my torts classes, which I'll show on the first day of class, this plaintiff, to get to the money, has got to clear a number of different hurdles. The first hurdle is establishing that the defendant owed him a legal duty. Second, he breached that duty. For medical malpractice claims, that means they were negligent. For product liability claims, it's a little different proof. You have to show that something about the product was defective. And that's not precisely the same as saying that the maker was negligent. Next, the plaintiff has to show that he suffered an injury that the legal system recognizes as an injury. Physical injuries, no problem. Emotional injuries, there's more limited recovery. And finally, he has to prove that there was a factual causal link between the defendant's breach and the injury. The negligence caused the injury. And that's a problem in medical malpractice cases a lot because patients are sick anyway. That's why they're in the hospital. And so a lot of this comes down to sorting out whether this bad thing that happened to them probably would have happened anyway, even if the negligence hadn't occurred. So again, these are all hurdles that the plaintiff has to get up and over through meeting this burden of proof. If he trips over any hurdle, he's done, and the defendant is going to prevail. Okay, so what are some of the distinctive problems that I think plaintiffs are going to face in this race? There are some that attach to the duty element, which is usually a no-brainer. In medical malpractice cases, no problem, because a physician-patient relationship, that's enough. But with AI, when you're also trying to sue a product maker, there are a couple of interesting wrinkles. One is that if the AI device itself was cleared by the FDA, a doctrine called preemption might apply, depending on the pathway of FDA clearance that it went through. And if it does, that means that there are no state law tort claims permitted against the maker of that product. The field of regulation is entirely occupied by the FDA. You can't sue the product maker. There's some uncertainty about exactly which devices are going to fit into that category, but certainly a lot of the radiological devices would. Secondly, there are some interesting questions that arise from the case law about developer liability in the presence of various kinds of contractual disclaimers. So for example, in the Samson case that I mentioned about the cardiac screening algorithm, that developer had been savvy enough to include in its contract with the hospital and the physician practice a line saying that because the ultimate decision about whether to conduct further screening rested with the physician, there was no legal duty flowing from the software maker to the patient. Physician practice signed that disclaimer, and it was enforced. This case was dismissed. Lastly, there are interesting questions that arise about the doctrine of misuse. So in product liability, a product maker can still be on the hook for injuries that occur because somebody misused their product, which is a really weird doctrine to a lot of people. That if I, use my toaster as a hat or whatever and burn my hair, as long as I can prove that the toaster maker knows people sometimes use toasters as hats, I can still hold that toaster maker liable for my misuse-related injury. It's only if the misuse is unforeseeable that I can't do that. And so then what does that mean for AI? We've got lots of uses of AI in ways that the maker, particularly the makers of LLMs, didn't necessarily know about or intend. There's the pediatric uses of AI that's primarily tested in adults. So we get interesting questions about what's foreseeable versus unforeseeable misuse. And particularly where we don't have like an FDA approval establishing what the approved indications are, it's very fuzzy. And again, that matters because it affects whether you can hold the product maker liable. So these are all duty questions. Then we've got a bunch of questions about breach. One has to do with whether you can hold a product maker liable in product liability. And that has to do with whether software is quote unquote a product. Historically, courts have not been able to view things that are intangible as products. And that makes a difference in terms of the standard of care that is applied. We don't quite know how that's going to turn out, but I just can't imagine that given the embeddedness of AI into all kinds of tangible things, that is going to remain a problem. A bigger issue has to do with proving what is reasonable behavior. Given the opacity of AI models, how is a plaintiff supposed to show that a physician made an unreasonable decision to follow an AI algorithm's recommendation or to depart from it? It's really hard. They've got to look inside the statistical patterns that drove the output and then show that the physician should have known that wasn't right. That's hard to do in general because it's very difficult to understand the math. And it's especially hard to do when the training data maybe didn't look exactly like the patient that was in front of the physician. How could the physician have foreseen that the model output would not have been as good for this patient as it would for patients in the training data? A lot of this is going to come down to what the physician knew about the training data for the model, what we know about the drift of the model over time, and basically the physician's ability to articulate a plausible reason for relying on it or not relying on it. Finally, and maybe the most tough thing for plaintiffs that want to sue developers is they have to show that the product was defective. And that means there's something wrong with the design of this AI algorithm that could have been avoided because there's some reasonable alternative design out there that would have been safer. Now, that's relatively straightforward to do for toasters. I can show maybe they should have put a cover over the top so I couldn't get my hair into it or whatever. But it's not so easy to do for mathematical algorithms that incorporate potentially millions of parameters. But that's what the plaintiff has to do. They have to show that they could have been designed in a different way mathematically, and if it had, this injury would not have occurred. That's really hard. And that brings me to my last point, which is that establishing factual causation is also really challenging for plaintiffs because they have to show, it's very clear from the case law we have, not just that their injury was related to some AI, but that their injury would not have occurred but for the defect in the math of the AI. Additionally, they've got to contend with the defense argument that it's not super weird to hold a physician liable for delivering care that on average outperforms human alone care. And that is hard to do if you're a plaintiff, because courts are always called upon to think about the counterfactual. What would have happened in a world where this negligence hadn't occurred or where the defect product hadn't existed? Would the patient still have been injured? And if the AI is better than human alone, it's really hard for the plaintiff to persuade people that the answer to that is, yeah, I definitely would have been injured anyway. Or sorry, that I would not have been injured anyway. All right, so plaintiffs have a lot of hurdles to clear in these cases, and I think it's going to be very difficult for them to do that, at least in the near term. So where does this sort of leave us? Can I have the next slide, please? I think I just ran out of battery here. Oh, hold on. Back one. Can we go back a couple? Okay, hold on. There we go. All right. So where does this leave us? I think plaintiffs are going to have a hard time because of the complexity of AI and the way in which that bears on the problems of proof that they have. I think they're also going to have a hard time because judges do not understand any of this stuff now. If you go back and read these cases, it is clear they don't get the difference between regular rules-based software and AI algorithms. They don't understand that difference. It's not meaningful to them. And so they're starting from a very, very low level and trying to convince judges and juries about what's going on here. At the same time, though, these cases make clear that there's going to be a lot of focus on the reasonableness of the physician's action in response to the output of an AI model. What should the physician reasonably have known about whether it was right or wrong to follow that output or not? And that can be quite hard, particularly when we start to get, again, outside the training data. So what I want to suggest is that rather than freaking out about liability in general, that we start to encourage people to think in a very granular way about risk assessment for AI. And that just begins with questions that I think most people fixate on the most, which are how likely is this algorithm to make an error in general or for a given patient? How likely is it that the way I'm using it in a clinical workflow is going to lead to an error? That's important. Of course it's important, the likelihood and the magnitude of the error. But if we think about 30 years of patient safety research, we know that the prevalence of error is not the only factor that matters. It also matters whether we have humans or systems in place that are likely to intercept that error before it reaches the patient, right? So the next series of determinations that we have to really think about is how do we create maximal opportunities to catch these errors before they cause harm? Can we think about loosening the coupling between an AI function and impact on the patient to create a little space for interception? Can we think about creating time for that? Tools where there's no time, where this pump is delivering morphine right now, those are going to be the highest risk tools, whereas lots of other tools, there is, at least in theory, time and decoupling. But finally, we have to be really honest about the situational opportunity for intervention here, by which I mean, even if we have theoretical time to do so, what is the actual likelihood that the human involved is in a position to catch this error and make a response to it? And that's going to depend on things like how visible is this tool? Is it something that's going to be top of mind, or is it in the background? People kind of forget about it. They sort of relax their vigilance. Are they working in conditions that allow them time for reflection, for investigation, for clicking through to make sure that things are as they seem? Then we have to assess the likelihood that this is going to cause a serious harm to the patient. So that's really the third element in my risk assessment framework here. And these are the elements that the FDA tends to focus on when it's doing risk assessment of software as medical devices. How severe is the health condition that it's operating on, and what is its clinical function? How important is that? All of these things are going to lead to the probability of an injury. But what the lawyers will tell you is you can't stop there. If really what you care about is not hurting patients but getting sued, which I know is not true for any of you, but if it were, you would also be concerned about a bunch of lawyer things, like whether this is the kind of claim that's going to be allowed to be brought under federal preemption rules, whether it's the kind of plaintiff who's going to find a lawyer, because most don't. Plaintiffs' lawyers turn away 90% of prospective clients that come to their offices because they're not good clients. They're either not attractive, they don't have big enough damages. 85% of injuries that get litigated in the medical malpractice system are serious or fatal injuries. Or it's just too hard to prove the claim. And that takes us back to all these problems with AI that make it really, really hard to prove claims. And so paradoxically, the AI tools that might involve the greatest degree of legal risk are not necessarily the same tools that involve the biggest risk of hurting people. Because the ones that will pop up in the legal system are the ones where causation is pretty clear, the defect can be easily sussed out and explained to a jury, and the injury is severe enough, and the plaintiff's young enough to have big damages. Finally, there are some gradations of risk associated with how the overall liability would get allocated. So, of course, tools where the developer has disclaimed liability, that's a higher risk tool for the hospital, for individual physicians. Or tools that are homegrown. There's no developer to bring into the defendant's table. In contrast, tools where the patient was involved, there might be some patient-related factors that might get a defendant out of some share of liability, or tools where the developer hasn't disclaimed liability, those are lower risk situations for hospitals. So all of this stuff should be in the mix. All of it should be fed into individual and institutional decisions about whether to adopt particular AI tools, because there is also risk associated with not adopting tools that improve care and reduce the prospect of injury. I think going back to where I started from, just remembering what it means to be a responsible user of AI will go a long way towards ameliorating some of the residual risk here. Because if you're a smart overseer, you're somebody who takes the time to check, doesn't over-rely, doesn't get complacent, those same principles of ethical use is what is going to constitute responsible use in the courtroom. Part of enabling people to be responsible users is making sure they have the right information. And it's amazing how many times I hear about institutions rolling out seemingly low-risk tools like AI scribes with zero training other than here's where you click, here's where you submit. Educating users about known failure modes, how to focus that 30 seconds that they have to read that draft email, for example, what to look for, that can be really crucial in reducing that residual risk. Documentation is just as important here as it is in any other area. Again, particularly if your decision is, I got an AI output from a good tool and I disregarded it, I felt it was wrong, record why. And then finally, there's this question of what to tell patients. My own evolving view is that it makes sense to tell patients about use of AI tools where one or both of two conditions exist. One is that it involves some risk for them. It's more than low. And secondly, they have some kind of opportunity to exercise agency if you tell them, which might mean, I want mammography without AI assist, or it might mean I'm going to, when I read your email from my patient portal, if I know it's generated by a bot, I'm going to question you about weird stuff that you say in it in a way that I wouldn't question you if I thought it came from you. So that can be sort of helpful at the margins in reducing the prospect of these additional informed consent-related claims. So this is not rocket science. This is like basic legal risk management principles that I think are not novel. They are important to remember as we sail into the AI age, but they're the same principles that have always protected physicians when they interact with technology. And a lot of these are also principles that can help prevent injuries to patients in the first place, which is always the best risk management strategy. So I'll close with some additional resources developing these ideas in greater depth, which I encourage you to check out if you would like to know more. Thank you very much.
All right. If you want to take a comment, himself. So let's get him a mic real quick. And if you want to hand that back over. You can take at least just one question.
Sure.
But we are at the break time, so actually reach out to Professor Mello and all of us. Great. Let's squeeze in one question.
Thanks for letting me sneak this in. Do you envision a future where it could be negligent for physicians not to use these types of tools? And then with respect to one of your points on the last slide, documenting inputs, outputs, reasons for accepting, rejecting, do you envision that we're going to need to have audit logs associated with these tools because they're stochastic in nature? And so without some kind of audit log, you can't really document all the things you suggested.
Yeah, I mean, for every tool that's going to be different, and this is not something that an individual physician is going to do, but it's not a good look if an organization can't say, for example, which tools touched a patient during her care on a certain date and which were, the versions of those tools that were running at the time.
All right, fantastic. I have 50 more questions, actually, myself, but let's feed them into the break. We will come back at 3 o'clock.